Hello, everybody, and welcome back to the next episode of SEC Roundup. My name is Nick Morgan. I'm with ICANN, the Investor Choice Advocates Network, and with me is my fellow board member and co-host, Tom Zucchero. Tom, how are you?
I'm doing well, Nick. How about yourself?
I'm doing okay. Can't wait to hear about this topic. We are joined today by our special guest, Susanna McDonald. Susanna is the Vice President and Chief Legal Officer of the Association of Corporate Counsel. Susanna, thank you for joining us today.
Happy to do so. Thank you for the invitation.
So we're talking about a very interesting case brought by the SEC. I say case, it's kind of a weird case, and Tom will talk about it in a minute. It's what's known as a subpoena enforcement action, which is like a lawsuit. And it's about a subpoena that the SEC issued to a law firm, Covington, to get certain information about Covington's clients. Tom, can you tell us a little bit about the subpoena enforcement action, how it came about, and why this is of such interest to so many in the legal community and elsewhere?
Sure, absolutely. So the case arises out of a hack of Microsoft by Chinese threat actors back in 2020. These hackers got into the Microsoft servers, which allowed them to get to hack into Covington and Burling, a law firm headquartered in DC. So that occurred. A lot of publicity around the hack itself. But 2 years later, the commission served an administrative subpoena on Covington. And the subpoena related to the hack and asked, among other things, for the identity of the clients who were hacked or who were affected by the hack, the public company clients, the nature of the information which may have been accessed by the threat actor, and the law firm's communications with its clients regarding the hack. Covington objected on numerous grounds, including, of course, attorney-client privilege and client confidentiality. The SEC purportedly narrowed their request to just the identities of the clients who were affected by the hack. Covington still resisted, and the SEC in January of this past year filed a subpoena enforcement action. That was filed in January, and Covington and a large number of major international law firms have opposed that request, the SEC's request to have the subpoena enforced. I think it's noteworthy that while just the identity of clients in and of itself may not be confidential or privileged, here the SEC is asking for a little bit more. They want the identity of clients who were impacted by the hack. And that second part of that request is the plus that makes it more than just client identities. And the SEC's rationale is we need to make sure there was no insider trading based upon material non-public information accessed by the hacker. And more importantly, from Covington's perspective, the SEC wants to investigate Covington's clients in their disclosures regarding the hack. So it's still pending. Obviously, lots of eyes on this case, and we'll see what the district court in DC decides.
Thanks, Tom. And you and I have seen a lot of subpoena enforcement actions over the years. This looks like a very remarkable one. It's drawn a lot of attention by the law firm community and elsewhere. And in fact, there have been a lot of amicus briefs or friend of the court briefs filed in support of Covington's position in this case. And among those amicus briefs, was one filed by Susanna's organization, the Association of Corporate Counsel. Susanna, can you tell us a little bit about why, the brief that your organization filed and why the association felt compelled to file it?
Sure. Well, one, as you know, we represent the interest of in-house counsel across the globe, well more than 40,000 members representing over 10,000 different organizations. And we felt compelled. One, we are staunch advocates for attorney-client privilege across the board, but particularly for in-house counsel. So any potential degradation of that privilege of any counsel will obviously impact in-house counsel as well. So we we monitor all cases that have the potential to do that. This case was a particular interest to us because of the fact that in-house counsel are not only counsel, but we are also clients to outside counsel. And we are very concerned if this type of administrative subpoena is allowed to go forward where client confidences can be breached, not only at the outside counsel level, but also to administrative subpoenas to organizations, then you are having a situation where more than 300 agencies out there have the administrative subpoena power, could continue to do this sort of administrative power and thus weaken attorney-client privilege and client confidences. So this was a keen interest to ACC, so that our in-house counsel can continue to have the same attorney-client privilege and privilege, in client confidences for themselves as well as for their outside counsel.
And have you received positive feedback, negative feedback, any feedback at all about the brief or the position?
A lot of positive feedback from our members, a lot of positive feedback from, of course, the Chamber of Commerce, as well as other law firms that we work with. As you know, many of our law firms out there love working with the ACC because we have a great book of clients for for the outside counsel. So we've gotten a lot of positive feedback on this. I think that it's an interesting problem. I don't think people are quite aware of how the necessary interplay between inside counsel and outside counsel. I think that that's one area that, particularly in the media, I think that it's been an interesting coverage for them. I think it's also been very interesting, to see how the judges are thinking along those lines. And I'm very interested in seeing what Judge Mehta is actually going to decide on this case, but he has sent it back out to the counsels arguing this case to get more information about, grand jury subpoenas and how they may correlate to this, which I think is a very different issue from an administrative subpoena. But my hope is, and I believe that Judge Mehta is really trying to put together a very thoughtful piece, because I think he anticipates, as we all do, that whatever decision he makes, that it will be appealed. And so he wants to have a good, thoughtful opinion delivered up to the appeals court so that they can make the appropriate deliberations that they need to make.
Well, we will look forward to seeing the judge's opinion and whatever appeals follow. It's obviously of great interest to the members of your organization and really to anyone who might receive or whose law firm might receive a subpoena from any of the agencies that have that subpoena power. So, Susanna, thank you so much for your time today. We appreciate your thoughts, and we'll keep an eye out for that decision and see what happens. Tom, thank you for joining, and to everyone else, please join us for our next episode of SEC Roundup. Until then, goodbye.